In this video, we're going to talk about Hong Kong Fir Shipping and Kawasaki Kisen Kaisha, a case about the classification of contractual terms. In this case, the claimant had hired out a cargo ship to the defendant under a 2-year charter party. However, the crew that the claimant had supplied was inadequate, and the engines had also suffered several breakdowns. The ship was therefore off hire for several weeks. By that point, there had been 17 months left of the charter party. In the charter party, there had been a clause which states that the ship is in every way fitted for ordinary cargo service. So the question is, was this a breach of condition, the breach of which would entitle the innocent party to damages, but also to entitle them to terminate the contract altogether? Or was this a breach of warranty, the breach of which would only entitle the innocent party to a claim in damages? Lord Justice Diplock in this case stated that this clause was neither a condition nor a warranty, and this was quite a novel step for the common law to take. Lord Justice Diplock states that there are many contractual undertakings of a more complex character which cannot be neatly categorized as being conditions or warranties. Of such undertakings, all that can be predicated is that some breaches will, and others will not, give rise to an event which will deprive the party not in default of substantially the whole benefit from the contract. And the legal consequences of a breach of such a term depends upon the nature of the event to which the breach gives rise, and does not follow automatically from a prior classification of the undertaking as a condition or a warranty. Lord Justice Diplock dubbed these terms innominate terms or intermediate terms. They go beyond the binary distinction between the traditional conceptions of conditions and warranties. So he states that innominate terms are an undertaking, one breach of which may give rise to an event which relieves the charterer of further performance of his undertakings, if he so elects, and another breach of which may not give rise to such an event, but entitle him only to monetary compensation in the form of damages. The former effect of a breach is of course traditionally associated with conditions, the latter with warranties. So this novel category of innominate terms straddles between these two binaries. Just when would a breach of a nominate term entitle the innocent party to damages only, or to damages and also to termination, will vary depending on the consequences of a breach. Applying this to the facts of Hong Kong Fir Shipping, Lord Justice Diplock held that since the breach here did not in fact deprive the defendant from substantially the whole of the charter party, the defendant was not entitled, therefore, to terminate the contract. The defendant, therefore, had wrongfully repudiated the charter party. This was because, as mentioned earlier, there had been about 17 months left out of the 2-year charter party had yet to accrue.